Is your business protected against the threat of malicious litigation and frivolous lawsuits? Are you sinking company profits into marketing campaigns that do nothing to contribute to the growth of your business? Bottled Business Sense provides practical business perspectives that uniquely emphasize both legal and media marketing strategies to protect and ensure the longevity of your business. Now, whether you're trying to provide a startup business with some level of stability or an established business with foolproof asset and estate protection, or simply attempting to get a better return for your business marketing dollars, Bill Bernard and Rick Moscoso will expose potential pitfalls to ensure the security and growth of your business, free from unwanted expense and the threat of litigation. You'll learn how to implement marketing and protection tools equal to those used by today's most successful corporations. Let's join Bill and Rick for today's Bottled Business Sense show.
Good morning, everyone. Today is Tuesday at 10 o'clock here on the Bottled Business Sense show. Welcome back to our regular viewers. And if you are new to this episode, welcome. I am Rick Moscoso, one of your co-hosts. And on the other side, we have Mr. Bill Bernard coming from the Aloha State. How are you doing, Bill?
We are doing fine, and I'll be back in California next month. And I'm looking forward to getting back to a little bit drier of weather. We're having a few hurricanes here, not on the islands, but south of the islands, and they are blocking the trade winds. And without the trade winds, you might as well be in a pool of water all day. You know, that's how humid it gets. So in any event, having said that, those hurricanes...
You have to take a shower after you take a shower. Huh?
Yeah, that's right. Well, you're in a constant shower, yeah. We're hoping that they swiftly move away here within the next few days. Anyway, our show today is called An Important Legal Update for Independent Contractors and Employers. And the reason for this is because even though this update hasn't happened just a few weeks ago, it is nevertheless important enough to bring to people's attention, because I'm not sure how many people follow it and how many people are aware of it, especially if you're an employer, and you should be. So for years, when employers went to hire people, a lot of times they tried to hire them as independent contractors in order to avoid having to comply with all the wage laws, of which there are many, and I believe we did a show on that at one time. And that particular status of California law said, well, in order to be an independent contractor and not an employee, we have to look at about 8 factors or so that will generally give us a guideline as to whether or not you are, in fact, an employee or an independent contractor. And the court said that these individual factors cannot be mechanically applied to every case. They have to be looked at as separate tests, and weight must be given to them almost on a case-by-case basis. So here are some of those factors. The court would say, well, were you performing services engaged in a distinct occupation or business? Were you doing something that wasn't typically what the so-called employer or the company that hired you typically does? In other words, you might be an IT company who hires a plumber, right? Plumber would have his own business, would be an independent contractor, not involved in the business of IT. Second factor was, what kind of occupation in the locale is typically performed by what you're doing. In other words, are plumbers in the locale where you're working typically independent contractors in the scenario in which you're being retained? Number 3, what's the skill required for your particular occupation? Number 4, whether you supply your own materials and tools, or does the person retaining you supply the tools and materials? Number 5, the length of time for which your services are contracted for. Are you working every day with this guy, or just whenever he needs you, he or she. Number 6, the method of payment. Are you being paid by the time you're on the job or in some other fashion? Are you punching a card? Number 7, whether or not the work is part of a regular business of the principal, which we've kind of referenced before. And number 8, whether or not the parties believe they are creating an employer-employee relationship or an independent contractor-employer relationship. Now, Rick, would you agree with me? That's a lot of factors to go ahead and try to resolve, right?
I would say.
A court's going to look at all those. It could involve a lot of expensive litigation. So the court came up, the California courts issued a decision called Dynamex, Dynamex, Operations W, the letter W, Inc. versus Superior Court. And it's a 2018 case. So it is rather recent. And they said, well, it's never been an exact science determining whether you're an independent contractor or an employee. And so we want to try to simplify this issue. And so they came up with what they have coined the ABC test. And the ABC test has been adopted under the IWC, which are wage orders, their wage commission orders that are issued. That's not really that important to our viewers, but suffice it to say that everybody on board in California is now in line with this ABC test. And in Dynamex, plaintiffs were delivery drivers who filed a class action claiming Dynamex had misclassified them as independent contractors. And they said, hey, we're not independent contractors, we're employees. The Supreme Court found that a worker, listen to this now, this is extremely important, folks. A worker is presumed to be an employee, and the hiring business must satisfy all 3 prongs of the ABC test to overcome that presumption. So I'm not going to give you that in a second. But number 1, now when you're hired for a job, you're presumed to be an employee, not an independent contractor. And number 2, if you're challenged, if both parties agree you're an independent contractor, no problem. But if you're challenged on that, it's up to the employer. He or she has the burden of proof to overcome the presumption that you are an employee, not an independent contractor, by the employer having to satisfy the 3 prongs of the ABC test. And those prongs are, ladies and gentlemen, that the worker is free from the control and direction of the hiring entity in connection with the performance of his work, both under the contract for performance and in fact. So you have no cause to listen to me as the so-called employer in the performance of your job. Now, I may hire you as an independent contractor and say, Rick, I want you to build an addition onto my house, but I'm not telling you how to build it. In other words, you're going to agree that I'm going to make the decision that what you're going to be doing is an addition onto my house. But that has nothing to do with the control and direction of the performance of your work. So if the employer can satisfy that burden, that's one step of the ABC test in saying, hey, you're an independent contractor, not an employee. Number 2, the worker performs the work that's outside the usual course of the hiring business, which you will recognize as one of the 8 prongs of the prior test. That's very important. So, Rick, you're a plumber, not an IT guy. So you're not working at my IT company in terms of performing IT work. You're being retained as an independent contractor as a plumber because we have a bathroom leak. Okay? So the worker performs work that's outside the usual scope of the hiring business's entity. So going back to our Dynamex case, if you're a driver for a ride service or a delivery person for a delivery service, you can't be an independent contractor, no matter how little control the company has over you, so the first part of control is wiped out. You can't have control over that person, because if he's a delivery person for a delivery service, or a driver for a ride service like Lyft or Uber, well, that's the work that company performs. So you're going to have to be an employee. And you remember the Uber case that came down not too long ago, where they all sued as they wanted to be employees, because they were saying, hey, we're driving around for you and you're a driver company. You can't just hire us and not give us all the benefits of being an employee and call us independent contractors. Yes, you don't necessarily, we can't make an argument, or excuse me, you can make an argument as Uber or Lyft that you have there is control or not control over the way we perform when we're a driver, but you can't get away from the fact that driving is what your business does. Okay, so you can't say that we're not an employee. And number 3, the worker is customarily engaged in an independently established trade, occupation, or business of the same nature as the workplace. As the work performed, i.e., a plumber, a painter, right? A lawyer. You're retaining a lawyer for some purpose, as opposed to in your IT company, right? So in number 3, the court will look at such things as whether the worker's business is incorporated, or whether it's an LLC, whether it's licensed like an attorney, whether it's advertised independently from your business, right? All of those things would make it such that they would be offering services to the public or other potential customers besides just you. So you can't be the employer. So I want to recap this. This is a short show today, but it's a critical update for employers to know. You're presumed to be an employee at the hiring time unless the employer can overcome that presumption by showing that the worker is free from the control and direction of the hiring entity in the performance of his or her work. The worker performs the work that's outside the usual scope of the hiring company's business. And number 3, the worker is customarily engaged in an independently established trade, occupation, or business of the same nature as the work that he or she is performing independently. That is what the ABC test is. It's much more refined. It's much more easy for the court to operate under, and it's much more easy for an employer to recognize when he goes to hire you, hey, this person is going to be an employee unless I can rebut the presumption by looking at these 3 tests, this three prongs, I should say, of the ABC test. One last point to make in this show. One question was left open by the Dynamex court. Will the ABC test apply to workers claiming labor code violations that aren't related to wage orders? What does that mean? Employers should review their own hiring and classification practices. So, will the ABC test will the ABC test apply to workers claiming labor code violations? So, in other words, if you're claiming a violation of the labor code, is the employer going to have to overcome those the presumption that you're an employee by looking at those 3 tests? Or if it's a wage violation, do you automatically get to go to the Department of Labor Standards Enforcement? That's a situation that was left open by the court, because these claims are not necessarily concerning just the payment of wages, because you're going to get wages whether you're an employee or an independent contractor, right? Mm-hmm. If you dispute what you're being paid, the court left open whether that ABC test has to be followed. The court only said the ABC test has to be followed to establish whether you're an independent contractor or an employee, not whether you have a dispute about the wages you're paid either as an independent contractor or an employee. In that scenario, you may still be able to just go to the Department of Labor Standards Enforcement to resolve that dispute. And that doesn't require a lawyer. Okay, so that's kind of it, folks, for the show. It's short and sweet. It kind of distinguishes what the differences are between the old law and the new law, which, again, the case came down in 2018. But what would you say, if you were taking notes, Rick, what would you say would be the most important thing to get out of this? And I'll give you a hint. Forget about the 8 prongs that we were dealing with in the old law, and now it's resolved down to the ABC test and the 3 prongs. What would you say would be the most important thing that the employer, I'll give you another hint, that the employer has to take away from this show? Watch this, folks. Let's see if he gets it. Let's see if he's listening to the show equally with the anticipation and interest that you have, I hope.
Well, I was listening, not as close as I was probably.
I don't think he's going to get it, folks.
No, I'm not going to get it.
Okay.
But can I phone a friend?
This isn't a game show.
Okay.
You don't get 3 helps or whatever they called it on that show. No, the important thing is that the worker is presumed to be an employee at the time of hiring, and that the hiring business must satisfy all 3 prongs of the ABC test to overcome that presumption and establish that the person being retained is an independent contractor rather than an employee. That's what you need to remember, the most employers out there. And employees, now you know what your rights are as well. So I hope that that everybody comes away with the knowledge that this law has changed and how important it is, because these types of lawsuits occur all the time. Okay?
Well, excellent update on that topic, Bill. I know, folks, if you are more interested in hearing more about independent contractors and employees or any type of work-related issues, Bill has a whole host, or we have a whole host of shows based on those topics. Go ahead and head over to bottlebusinessshow.com and search for those specific keywords, and you can see our past episodes that we've done over the last 5 years.
Yes.
And we've done a whole host.
We have, and you can also go to my website, wfblegalconsulting.com. There's a drop-down box where you can actually watch any episode of the Bottle Business Sense show you want. It's tied into the Bottle Business Sense website. We have not forgotten about the other 2 prongs of my business model. Remember, business attorneys should handle employment law, estate planning, and asset protection, in my opinion. We have some upcoming shows in asset protection and estate planning. I think we just finished an estate planning show a week or so ago, by the way.
Yeah, we did.
Concerning living trusts and what you really need to know about them.
Mm-hmm.
So we will be following up on that. And if you have any suggestions or you have any topics that you want us to address, please let us know. Because we do have emails, and we did that in a prior show, and one of our upcoming shows concerning asset protection will be addressing a specific concern of a few individuals that have contacted me. So, Rick, to end the show, where can they contact us in terms of email and phone numbers so they can let us know what topics they might be interested in?
Absolutely. Well, you're probably watching this on YouTube, so bookmark this channel. And look back at previous episodes, or go to bottledbusinessshow.com. We're also on social media, Twitter, Facebook, YouTube, and LinkedIn. So just type in the Bottle Business Sense Show keyword and you will find us. Reach out to us at any of the contact information below this video, or if you have specific requests, topics that you'd like to hear about, drop us a line, drop us an email at bottledbusinessshow@gmail.com, or specifically to either of our emails below this video. So, Bill, thank you again for the update. That's very, very important news. And by the way, I was listening.
I knew you were. I'd just like to put you on the spot. What's the point of having a co-host, folks, if you can't put them on the spot once?
Yeah, right.
There you go. Well, we look forward to the next show. And I think it's a topic that Rick's going to be addressing directly, as a matter of fact. So tune in and watch for our advertisements on Facebook and Twitter and LinkedIn. And we'll see you next time.
All right, Bill. Thanks again. Folks, we'll see you on the next episode of the Bottle Business Sense Show. Take care.
Bye, everybody.